to Uniquely Mia's Criminal Justice 101 Perspective and Policies class. Welcome back if you are a returning student, and welcome if you are new. If you are a new student, make sure to like the video, follow along, and leave a comment to secure your seat. In this video, we're doing something a little differently. We're going to do a case review. That essentially means we're going to take a deep dive into a case. We're going to look at the facts section, the procedural history, the issue, the holding and rule, rationale essentially saying why did the court come to this decision, and my opinion. Should be noted, all information that I'm telling you are based on like peer review academic journal articles, and for this case review, this was a discussion post that I had to write for my class, got 100 on it, so I actually read I think it was 30 pages. I read all 30 pages of the case review. The case that we will be discussing today is Hudson versus Michigan 2006, and 2006 is essentially when the case case brief, it was released to the public. However, the circumstances in the case, it did occur, it occurred in the year of 2006, but it did occur over the course of various months. Should be noted, when reading the case review, when citing the rationale and the majority opinion of the judges, this was done in something known as a judicial review. That essentially means that, so a judge, when the defendant appealed the decision that they initially received, they appealed it to a higher court, and then ultimately I think it was appealed to the Supreme Court, and via that judicial review, judges, they interpreted the actions of the police officer, the action of this defendant, and the actions of the state law to mean this. So basically what I'm telling you, I have to put that disclaimer in here because, for example, when I go over this case, you may be familiar about a criminal justice case, and you may say, wait, based on this case, the facts are completely different. That's okay. That can happen because of judicial review. So there was a defendant, Booker Hudson, and he was a defendant who essentially was in his home. I believe it was 2 or 3 Detroit police officers. They entered his home without knocking. And in the criminal justice system, when police officers are acting in their role, specifically if they have a warrant and they're going to somebody's home, if police officers are outside of my home right now and they have a warrant, they have to knock. This is essentially known as knock and announce. This means they knock on the door and they wait 20 to 30 seconds for me to go to the door. And this is generally, it's in law, and it's the preferred method used by police officers because it allows police officers to ensure that they are not damaging property of the defendant or the individual who lives in the house, to ensure that the individual has time to maybe become decent, put on proper clothing, ensure that the individual has time to review the warrant, to ensure that, hey, are you actually at the correct location? Are you here to see me or someone else? And to point out any errors that may be present. Within the knock and announce rule, there are some exceptions. Exceptions includes if a police officer has a no knock and announce warrant. Obviously, no knock and announce warrant means they can enter without knocking or announcing their presence. Police officers can also enter a unit without knocking and announcing if they have reasonable belief or reasonable suspicion that contraband, illegal drugs, perhaps a weapon will be destroyed if they knock and announce, or they do not have to knock and announce if they believe that doing so would put themselves else in the unit in danger. Perhaps if it's a hostage situation or something like that, police officers do not have to knock and announce. I'm going to be looking down a lot because, as you can see, I have a lot of notes and I want to make sure I get the facts correct. So I'm just going to be reading this and looking at you while I do this. So this is the facts of the case, and the facts of the case, it's essentially what facts mean. You can't try and dispute this because this actually occurs. Arrived at Booker Hudson's home, and we will then, throughout the video, I will be referring to Booker Hudson as either Hudson, the defendant, or the petitioner. That's how you can refer to a defendant in criminal justice system or just informal writing. So police officers, during this search, they had a warrant. So they had an actual warrant, so they were acting in good faith, in the good faith exception or the good faith doctrine, and they had a reasonable, valid reason for being there. In the warrant, it specified we want to search Booker Hudson's home for contraband. Contraband means drugs and weapons. So officers, they had that. However, what officers did not do, they didn't knock and announce. They knocked, but they only waited 5 seconds. So that was a violation of the knock and announce rule, because as I said earlier, you have to wait between 20 to 30 seconds before entering. When the officers entered the unit, they found drugs and a loaded firearm, and the gun was found between the couch cushions. So once inside, the officers charged Hudson for the drug offense that they found, as well as the illegal weapons, and then Hudson was then arrested. So the case first occurred on January 9, 2006, and it was appealed. So then when it was initially appealed the first time, it was reheard on May 18, 2006, and then ultimately the final decision was made on June 15, 2006. So as you can see, it was a fast process when you're looking at criminal cases or just cases in general in the criminal justice system. So now we're going to go to the procedural history section. This procedural history section is essentially saying, okay, this is what the first court charged Hudson with. This is what they said. This is the rationale that the first appeal court or the appellate court used to support their decision on why the defendant was pardoned or not pardoned. And this is what the Supreme Court ultimately said or what they did. So when Hudson was first arrested and he received his sentence under Michigan's law, he submitted a motion to suppress. And this motion to suppress essentially means it's a motion that whether you're an attorney or just somebody else, you have this option to submit this motion to suppress. And as the name suggests, you're trying to suppress some type of evidence or some type of legal document within a motion to suppress. So Hudson submitted this motion to suppress because he wanted to suppress the items that were seized by the officers under the grounds that they violated the knock and announce rule. However, the Michigan trial court, this is the lower court, they initially granted his motion to suppress, noting that the entry into Hudson's home did violate his Fourth Amendment rights of unreasonable searches and seizures. However, the Michigan Court of Appeals, they reversed this decision. They noted that relying on Michigan Supreme Court cases, prior cases in the past, that suppression of this evidence was inappropriate because the police officers had a valid warrant to enter into the unit. So therefore, this ultimately led to the conviction of Hudson for the drug offenses. However, after the conviction occurred, Hudson and his Fourth Amendment right renewed. He submitted another appeal request saying, hey, I want to appeal this decision. I don't think I was sentenced fairly, appropriately, but this was rejected by the Court of Appeal. So my question was, under the Fourth Amendment, does the police failure to knock and announce by waiting 3 to 5 seconds before entering Hudson's home, even though they had a valid search warrant, violate the unreasonable searches and seizure clause of the Fourth Amendment and enable the exclusionary rule to be applied to the evidence obtained? So before we go forward, just note that the exclusionary rule, it's very similar to the motion to suppress, but it applies to evidence. It applies to a lot more documents and items seized by police officers than motion to suppress. So this exclusionary rule is basically saying if officers act in an unethical or unlawful way and this led to the seizure of evidence, this evidence may be excluded and can't be used against the defendant in the criminal justice system. So ultimately, it was found that the officers did not violate the defendant's Fourth Amendment right of unreasonable searches and seizures because they had a warrant. This having a warrant is the foundation of police officers. It's the preferred method, and when they have it, they are generally protected. Even though the officers didn't knock and announce, this warrant allowed the evidence to be admissible in court. Interestingly, rationale for this decision came from prior Supreme Court cases. So 2 Supreme Court cases that helped come to this decision were Wilson versus Arkansas 1995 and United States versus Banks in 2003. Both cases ultimately found that it is not necessary to knock and announce if doing so could cause a threat of physical violence or the destruction of evidence, which could occur in about 15 to 20 seconds. So as it suggests, judges, they looked at these cases and they said, hey, if officers actually waited the preferred 15 to 30 seconds or 15 to 20 seconds, the evidence could have been destroyed because one of the main evidences or one of the main items of contraband that was found in Hudson's home was cocaine rocks, they said. And they said if you flush it down the toilet, it can be destroyed. So judges, they looked at that and said, you know what? Officers, they were acting in good faith. So under these two Supreme Court cases, the evidence shouldn't be excluded. Segura versus the United States, 1984. In this 1984 Supreme Court case, when judges analyzed this case, Supreme Court justices analyzed this case and applied it to Hudson v. Michigan, this 1984 case essentially proved the evidence to be used and discredited the defendant's claim that the evidence should not be admissible in court. So within this 1984 case, officers, they followed the defendant from a store into their apartment. Officers illegally entered the defendant's apartment and stayed in that apartment for 19 hours. Officers had no valid reason for being in that apartment. They had no legal reason for being in that apartment. However, they waited for 19 hours until a search warrant was approved by a judge. Once a search warrant was approved, they searched the apartment. They found illegal evidence / incriminated evidence, and this incriminated evidence was admissible in the 1984 case to convict the defendant. So when you compare this case to the Hudson v. Michigan case, you essentially see officers in Hudson v. Michigan, they acted in a more legal manner than the officers did in 1984. Because in Hudson, they had a warrant. Remember I said earlier, having a valid warrant is very important, because having a valid warrant, even if officers or even if the warrant is later discredited or found to be false or shouldn't be applied anymore, as long as officers are acting in good faith and acting under the warrant, evidence can still be admissible in court, and the officers are also protected from civil liability. So in the Hudson v. Michigan case, they had a valid warrant, they had a valid reason to be there, and they still knocked and announced, but they only waited for 5 seconds. So ultimately, this 1984 case said, okay, you know what? If evidence was admissible when officers acted in a legal manner, then evidence should be admissible when officers acted in a legal manner. What are my opinions? I'm literally going to read what I wrote for this discussion post. So I essentially said, from reading Hudson v. Michigan 2006, it is apparent that one of the main factors used to convict Hudson was the evidence found in his apartment. And the basis of Hudson's appeal was that officers did not wait long enough for Hudson to open the door before the officers forcibly entered into Hudson's home. So the majority of opinion by the Supreme Court justices show that though the officers might have entered into Hudson's home lawfully, they did not in fact do so. Their unlawful behavior categorizes their actual entry, and that entry was a necessary condition of their presence in Hudson's home, and their presence in Hudson's home was a necessary condition of their finding and seizing of evidence. And then I went on to say, it is my belief that Hudson's Fourth Amendment rights was not violated, and that the officers had just cause to enter Hudson's home, conduct a search, and arrest Hudson. It did violate Hudson's knock and announce rule or right, because they did not wait the 15-30 seconds before entering Hudson's home. And doing this could put the officers' lives in danger as well as the defendant's life in danger. So the moral of the story is, guys, do not commit crimes. These videos are just to educate you and to let you guys know about like some of the rules that if an officer's ever outside of their home and if they're just doing like, I don't know, neighborhood sweep or something like that, just know in the back of your head, officers, they're going to knock. 9 times out of 10, they're going to knock. They're going to announce their presence, and you have about less than a minute to open the door. When you knock and you open the door for officers, you also have a right to review that warrant to make sure, hey, are they at the right location? Is the warrant correct? Is the date of the warrant correct? Because if the date of the warrant is incorrect, the officer can't enter my home. They can do whatever they want. But like, you can always appeal that decision, and you may have a good chance of winning. You may or may not. So hopefully you enjoyed this video. I will be back with more criminal justice videos very soon. And feel free to leave a comment. What did you think about the Hudson v. Michigan case? Have you ever heard of this case before? Or maybe a similar case that came to a similar decision? And were you surprised to learn about any of the rationale behind from other cases that we went over in this video?